Hello, this is Matt on the Moon Lambeau channel. This afternoon, attorney John Deaton shared the news that all deadlines are terminated, and that's a direct quote, and that's in regards to the SEC v. LBRY lawsuit, which we've all been following in the XRP community, and we know, I don't know to what degree, but we do know that that case, which is going to end prior to the SEC v. Ripple case, will have an impact on the Ripple lawsuit. So what's going on here? Why have all the deadlines been terminated? Well, first of all, the reason this is important is because there was a self-imposed deadline by the judge in the SEC v. LBRY case, and it was something like a week and a half ago. And the judge just didn't meet that deadline. They were supposed to be either a determination in regards to summary judgment in terms of which side would win, SEC or LBRY, or there was a third option. Technically, he could have come back and said, look, we're going to have a jury trial. That didn't seem probable. I mean, it could happen. It still could happen, actually. But those were the options. But there was just silence. There was nothing. The deadline came, the deadline passed, and there was nothing. And then it gets to the point where you reach the end of business yesterday, Friday, and still nothing, which is a problem because the case, if there was to be a jury trial, is supposed to start October 3rd. So this left a lot of questions out in the wild. I was publicly talking about it on Twitter. I'm like, what does this mean? What is going on directionally? Attorney Jeremy Hogan was talking about this as well. There's a tweet on the screen. I'll read it in a second here. So we were all just kind of left in the dark. And even LBRY themselves were not contacted. Even they didn't know what the hell was going on. Well, now we know, and I'll explain why we know of this. All deadlines are terminated. Now, interestingly, and I'm going to let John Deaton speak for himself, he actually thinks that these developments, although kind of annoying and it's kind of crummy that LBRY specifically was left in the dark, Attorney John Deaton actually thinks that these developments are probably good. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. There's an XRP community member who goes by the name Crypto and Bourbon on Twitter who is asking, hey, isn't this ruling due tomorrow effectively? And then tagged attorney Jeremy Hogan, attorney Deaton, and some others within the community. And attorney Jeremy Hogan saw that and did respond. And mind you, this is on September 29th. So 2 days ago, Thursday. And attorney Jeremy Hogan responded with, I think if the judge doesn't rule tomorrow, the parties show up for trial Monday. And so I was reading that and I was like, whew. Because mind you, if that's the case, you have to be preparing the whole time up to that point. Now, technically, any good attorney should be doing that anyway. But if there was going to be a summary judgment, now though there isn't, at least to this point, it would be nice to let them know so they don't have to do that. But I know that's not how the world works. And so the LBRY account yesterday afternoon, because they were getting bombarded with questions like, hey, what's going on? Do you know anything? There's supposed to be some sort of determination by now, right? You know, you're talking about Friday afternoon, and then, the trial's supposed to start, what, Monday? Because it's again Friday afternoon. It's supposed to start 3 days later, and we still don't know anything. And so they're getting bombarded, understandably, with questions. And so LBRY account here, the official LBRY account on Twitter, they did speak up. And they tweeted out the following. We just spoke with our counsel. Everyone was expecting a ruling in the SEC case by today, but the judge has not provided one. And so it's pause to note. The initial deadline was a week and a half ago, but I think the reason that they're saying expected by today is because if not received by, well, they wrote it yesterday, so if not received by the end of business yesterday, what's the alternative? Jury trial Monday? Like, what does that even mean? And so then LBRY wrote, the judge is now overdue on his own stated timeline, but that's his prerogative. Until then, there's nothing to do but continue to wait. We think the delay in ruling increases the odds the judge will split the baby or send the case to a trial. The delay will also give time for the judge or his clerks to read the Ripple filings. So while the delay is not fun, it's not necessarily bad. Yeah, and so I'll say this. And I was wondering this, and this is really, in fact, that comment right there is what got me thinking down this path. But I am wondering, I can't help but wonder, if the Ripple lawsuit did in the first place have anything to do with this, because this is such a crucial case. and it's going to be contested. You know, you can count on that. I mean, I think it's very reasonable to suspect whoever loses, they're going to appeal. That would be my guess anyway. And, you know, certainly now, with the judge having terminated the deadlines, which I'll get to in a second, certainly now the judge will have all the time in the world to read the SEC and Ripple motions for summary judgment, as well as the amicus briefs from the Chamber of Digital Commerce, also the amicus brief from Ripple customer and on-demand liquidity user iRemit. And they filed an amicus brief yesterday. I made a really, probably way too long video about it. It was like 38 minutes, but I wanted to be thorough, so it is what it is. And then there was TapJets. They also happened to file an amicus brief yesterday in support of Ripple's motion for summary judgment. And they happen to accept XRP as payment to gain a competitive edge against their, against their competitors. And they charter private jets. And they have a business model that literally could not exist if not for cryptocurrency, and XRP's the most popular cryptocurrency that's utilized within their business model for that portion of it anyway. It's crazy stuff. It's awesome stuff. But now, given how big of a deal this is, it sounds like the judge at least is taking this seriously, very seriously, and not rushing out of judgment. So, it just makes me wonder if, given the severity of this and how intense and important this is, how impactful a case this is, if the judge is just being extra triple super careful in the judgment here and needing extra time perhaps to look all over the stuff that's happening in other cases, specifically the SEC v. Ripple case, because there are a lot of arguments that are in the SEC v. Ripple case that could really help the judge understand exactly what's going on and get understanding from people that are in the space, so you can understand the utility, the technological aspects, but also get the legal reasoning from participants, because we are talking about a number of amicus briefs here, actually, and so they're talking about the legal implications and is there a common enterprise and all sorts of things along those lines. So Attorney John Deaton, he retweeted that from LBRY, and he wrote the following: "I choose to believe this is good news. 1, the judge is not rubber stamping the SEC's arguments. 2, he realizes the public interest this case represents and is being careful and deliberate. 3, it is likely to be appealed and he wants to get it right. I hope LBRY gets a complete sweep and wins outright. If he splits the baby, hopefully the worst case scenario is that he finds a specific sale early in the platform's existence as the sale of a security, but ongoing and future sales are not." Yeah, so that would be fine. I mean, I don't want LBRY to get slammed with anything, but I'm saying as long as there's a path forward, I think even LBRY would be like, okay, we can live with this, because that's what's actually important here. But it does make me wonder if that's going to happen. Maybe it will. But just as a layperson who doesn't have a legal background here, I'm sitting here wondering, okay, the SEC, so far as I know, they're not asserting that any specific sales were violations. They're just citing like the totality of the scheme, kind of like they're doing in the Ripple case. That's my understanding. So if that's the case, can the judge just still pick out some sales? Apparently, it sounds like that based on what Attorney John Deaton says. And if that's what's going to happen, okay. But if that happens, that provides a reasonable path forward, even if it's not binding precedent. That would be, not the end of the world for the SEC v. Ripple case, because even if Ripple gets hammered, as long as they, with fines, that's what I mean, even if like specific sales were cited by the judge in the SEC v. Ripple case and they have to pay a fine, okay, because what matters to Ripple most is that they can move forward with their damn business model and open up on-demand liquidity in the United States again, because it's been shut down for almost 2 years at this point, which is ridiculous, because the largest corridors in OTL used to be touching the United States, obviously no longer. I don't think they care. As long as on a go-forward basis, they can continue on with their business model utilizing XRP as a bridge currency, and they can sell to strategic partners and all that jazz, everything's fine. I don't think they're going to care about paying any sort of penalty anyway. And then in a tweet this morning from LBRY, they wrote, "When we're behind on a timeline, we work weekends. When the government is behind on a timeline, you don't even get an apology note." I think that's a not so vague jab at what's happening in the case. That's my assumption here anyway. So as far as the reasons, I think it's like they've bitten off more than they can chew from a legal perspective. And so this morning, I retweeted that, and I wrote, "It's just ridiculous that the judge hasn't told LBRY what is going on. No summary judgment, no communication on what to expect moving forward. Apparently, trial just starts Monday. And that was at 11:48 a.m. Central Standard Time. I tweeted that out. Because we were all in the dark. We're like, what in the ever-loving hell is going on? Or even the LBRY didn't know. And then this afternoon, Attorney John Deaton at, let's see, this would be 1:10 p.m. Central Standard Time, he tweeted out the following. I see a lot of comments about the pending LBRY summary judgment and trial date that was previously set. I knew that there was no real set trial date any longer, but I couldn't recall how I knew that, so I didn't comment. So I did what any reasonable lawyer would do when he knows something but doesn't know how he knows it to be true. Ask Jimmy Fallon. He pulled the docket and all deadlines are terminated. At oral argument, judge stated, quote, everything is stayed until further notice, end quote. And I'll just note that stayed just means that all legal proceedings are halted until further notice. That's all that actually means there. And so he tagged Jimmy Fallon here, James K. Fallon, a member of the XRP community member. Remember, that is a broken, I think my brain just like misfired. I don't know what the hell happened. It's like got 8 cylinders up there, like a couple misfiring. I don't know what the hell's going on there. Attorney Fallon, member of the XRP community. He's the one that shared this information with Attorney Deaton, and now we have a screen grab. I'm not going to read this, but for anybody that's curious, I'll make it full screen for just a few seconds here. Right now, if you want to read it, go ahead and just hit pause here, but I'm going to go ahead and move forward. And there was a question by an XRP community member named Stephanie Starr who wrote, I'm confused. It says all pre-trial deadlines stayed, but the last one says deadlines terminated. And Attorney Fallon did take the time to respond, and he wrote, deadlines terminated is the name of the entry on the drop-down menu on the court's docketing program. That's why the language is different. But what the judge is saying is that there will be no more activity in the LBRY case until he decides the summary judgment motions. So there you go. That does mean that there could potentially be a jury trial. I don't know if that's probable. At this point, I'm just going to go with what Attorney Deaton said here, which his suspicion is that this means that there's probably going to be a splitting of the baby, which sounds pretty gross. But this idea that maybe there'd be some sort of fines or something, but then on a go-forward basis, everything might be okay. We could all live with that, just anybody in the crypto community. So let's just hope that's all that is. But we shall see. We'll keep monitoring this. I'm sure there'll be news on it soon. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.